This is Justin Leto from LevelEsq. Today, I have the privilege of talking with David Kulwicki, a lawyer at Mishkind Kulwicki out of Ohio. His firm has been using Level Insurance on, I believe, some medical malpractice cases. And we're here to talk to him a little bit about how he's used Level, how the firm benefits from it, and just how he's learned about the program and sort of changed the practice a bit to start using insurance, because obviously it's a newer product and want to hear from lawyers about their experience. So David, thank you for taking a couple of minutes to talk with us.
Happy to help.
First, tell us a little bit about your practice, about what you do, what kind of clients you work with.
So I do about 100% medical malpractice, representing patients who've been injured catastrophically throughout the state of Ohio.
And so I understand, I know because as a former medical malpractice plaintiff lawyer myself, I know that there's some sort of unique things about Ohio Med Mal, particularly because the university, Ohio State University, has such a large swath of the doctors and the hospitals under its control. So you guys face some extra challenges when you're bringing these cases, right?
Yeah, I mean, they're very difficult cases in the state of Ohio. Statistically, the Department of Insurance tells us that the doctors and hospitals win 79% of the time. So they're challenging cases. Specifically, you mentioned cases against the Ohio State University, which is a public entity, and you have to sue it in the Court of Claims because it's a wing of the government. And that's a very challenging place to get a verdict in the Court of Claims.
And your clients don't get a jury in those cases, right? The judge has to be the one to make the decision?
So solely in the Court of Claims. In other cases, we do get a jury, but cases brought against the state of Ohio, which includes the University of Toledo's Medical Center, Ohio State University, and University of Cincinnati's Medical Center, which are three major entities in the state of Ohio. There's no jury trial there.
You know, knowing, obviously, I don't know a whole lot about the practice there because my practice was in the state of Florida, but I'm thinking about this sort of in two different ways. Obviously, juries around the country have been poisoned by all the tort reform ads, making people think that medical malpractice is this awful, terrible thing that's going to drive up their health insurance rates. So a lot of times you have a challenge just with a jury in general because you start behind because of politics. Do you think, is there any benefit to having an informed judge make the decision, or would you still rather have a jury?
I'd rather have a jury. The judges in the Court of Claims, as an example, are horrible. I mean, they are very pro-government, anti-plaintiff. It's very, very difficult to get a verdict there. And if you do, oftentimes the amount they award is paltry compared to what the actual damages are. So I would always prefer to be in front of a jury myself.
So this begs the question, because I think a lot of lawyers in Florida had the same question when our sort of arcane, terrible caps were in place, which they've since removed. Why practice in an area that is so difficult when there's so many different areas of personal injury that would seem to be somewhat easier to make a living? Why would you choose medical malpractice as your calling?
Well, I enjoy the challenge. I mean, it's what I do. It'd be like reinventing myself if I were to try to do something else. I've learned a tremendous amount of medicine over the years. I feel like I really enjoy getting to know the patients and becoming a part of their life in a particularly tragic episode of their life. It's personally rewarding. And, you know, I've had success in the field as well. So despite the challenges, I'm able to run a productive law firm and, you know, make a living at it.
What I found also, and I don't know if it holds true for your practice, is despite the difficulties and the statutory areas of concern, the defense lawyers on the medical malpractice side tend to be very intelligent, somewhat more practical, I think, because they're dealing with catastrophic injuries. So even if the cases when they actually get to trial don't have a great win-loss percentage, at least in my experience, you tend to have people on the other side who are a little bit more practical in their approach to getting the cases resolved. Do you find the same thing in Ohio?
It's a mixed bag. I would say when you're dealing with a nonprofit hospital that there is some rational decision making that's made and some fairness that enters into the math. I would say when you're dealing with a for-profit insurance company, they, you know, they get their fight on. They are very mercenary. They don't care about, they don't sympathize with the patient at all. They are strictly, looking at it from a business risk analysis perspective, and they can be very difficult to deal with, and it's tough to settle cases with those private insurers.
No, that makes sense. That's a very good point. When did your firm first learn about litigation cost protection and the fact that you could actually insure the cases that you guys were filing for these medical malpractice actions?
I would say it was a couple of years ago, pre-COVID-19. I think the first case that we got insurance on was probably 2, 3 years ago, maybe 4. And we first learned about your product through an Ohio Academy or Association of Justice. There was a convention, and I think you guys were presenting at it. And I got to talking with the representative there, and it just made sense to me.
That was probably my business partner, Larry. He's been pretty active at the Ohio Association for Justice. I think he's actually coming there for your next conference, which is in a couple of months. We've had great success. Ohio lawyers have really tended to understand the benefits of this product. Different states, different results, but Ohio has been great. And it's nice to hear that presence at those conventions actually matters, that you guys are actually listening to the vendors. That's really important. And so do you guys have a process in your firm by which you decide which cases will or will not be insured by Level Insurance?
I would tell you this, that my goal is to get insurance on every case, because every case has the potential to go to trial. Sometimes we miss the opportunity because the period within which you have to get the insurance either comes and goes without us thinking about it, or it, when we do think about it, the time for applying for coverage has expired. But frankly, I would like to get it on basically every case would be my goal going forward.
You got to put a calendaring system together. You file a case, it's got to be part of the process. But when you file these cases and you buy insurance, are you passing the premium on to your client as part of your contractual arrangement, or are you eating the cost yourself?
I don't. I know you can. I know there are some ethical opinions out there that allow you to do that ethically. My feeling about it is that is, I'm agreeing with my client to take on a certain amount of risk when I handle this case in terms of my time and my expenses. And I feel like if I can, outside of that client relationship, if I can curtail my risk as a business method, I think that's appropriate and wise. I don't personally like the concept of pushing it off onto my client. Again, I know that's ethical. My personal feeling is that if I'm curtailing my risk, I probably should curtail my fee, and I'm not really willing to do that. I think it'd be hard to assess how you would modify your fee to reflect the reduction in risk that insurance provides. So I just, rather than getting into that sort of discussion, I just sort of have conceptualized it as, this is me as a businessman minimizing my risk through the purchase of insurance, and it really doesn't involve the attorney-client relationship. That's my own personal feeling.
No, I think that's shared by a lot of lawyers that we speak with. Everybody treats it obviously very differently depending on how they view the insurance itself. But I've heard that from several lawyers. What I find interesting is you only really hear that from the guys who were consistently from the people who were doing primarily the medical malpractice. I'm not sure the reason for that, but we also, like, for instance, we insure commercial contingency cases. Commercial contingency cases, in a lot of situations, the lawyer is getting like a 35-40% fee, and the client is still paying all the expenses. So the fee that they're taking is contingent just for their time. But I guess just historically speaking, folks who are doing more high-end personal injuries see both the fee and the costs as being a contingent part of the arrangement. Obviously, that's how you've treated it as well.
That's correct. Yeah.
No, that makes sense. I mean, and it's virtuous as well. So I appreciate the way that you handle that with your clients. When you say that you prefer to have it on every case, does your firm handle anything other than med mal? I know you're a specialist in med mal, but do you all take auto or trucking or any other type of personal injury cases?
I have a subspecialty in traumatic brain injury cases, and those tend to have significant expenses. And that expense is growing as the field becomes more, there's sort of a cottage industry of defense experts out there that we have to combat. So these cases are becoming expert intensive, which means costs get driven up. So those cases arise out of all kinds of different scenarios. I had one where I think the Hassan case is one of the cases that we insured through you. We ended up resolving the case, but it was a gentleman who had gotten donated blood and was basically sort of ignored as he was having some of the complications of giving blood, including syncope. He walked outside, lost consciousness, fell, and sustained a significant brain injury. And that was a case that we got insurance on because our expenses were in the high seven figures, or I'm sorry, the high six figures.
Wow.
And we, fortunately, were able to resolve it. I should say high five figures. Now I don't want.
I was gonna say, I don't think your policy doesn't reflect the amount of money. You should have got bought more insurance.
I'm having problems with math. They didn't say there'd be any math in this.
No, I actually wanted to talk a little bit about maybe one of the cases that you litigated that was insured by our insurance, because I want people who are watching, because remember, people who watch this aren't just lawyers. There's also people potentially who are looking for a good lawyer to understand the process. And I know from my own experience, despite medical malpractice getting a very bad rap in the media and in politics, you only bring a medical malpractice case if the injuries are catastrophic and the people are awfully affected or there's death, because they're just too expensive to handle otherwise. So I know the process that you go through and the amount of time and the money that you put into these cases is impressive. So would you give us a little bit of an understanding of the process that you went through, let's say either in the Hassan case or the Baker case, and what it takes for you to get from point A all the way to the end to get your client a great result?
It's difficult. I mean, it starts with case selection. And as you mentioned, we have a threshold where we can only really economically handle either catastrophic injuries or cases where there's a slam dunk. And those are rare and far between in medical malpractice. We inevitably can commit somewhere between $30,000 and $50,000 of our time to each case, and usually a similar amount of our money. Oftentimes our expenses range from $25,000 up to $125,000 per case, depending on the type of case and the number of experts that are needed. Every case you work up as if it's going to trial. So we put a tremendous amount of effort at every phase of the litigation. I hope that answered the question.
It does. I'm wondering also, have you and your firm decided to let the defense know that you have these cases insured, to sort of use it as an offensive item and not just as a defensive item? Have you ever considered that?
I have. And I think it's sort of a game changer. I think the insurance is a game changer in the sense that it allows us to plow unlimited resources into our cases and really go for the gusto on every case, without any sort of feeling like, man, I got a 50% chance I could lose this case and be out $100,000, $150,000. So, I do let the defense know that I've got nothing to lose, other than my time. So I do use that as a bargaining chip. I don't know what effect it has, but I certainly lay it out there.
Well, what was like the first time you ever told a defense lawyer about it? Did you get a reaction as to what you're saying?
Absolutely. The eyebrows go up and I get the, really? What? And, my hope is that they send that information back to the people that make the decisions on whether to settle or not. I definitely disclose that information freely.
Yeah, it's interesting because I think that's become more of the norm. It's obvious that the insurance covers you for your downside, but the potential upside that you can get from disclosing this, because I know you as a lawyer with a lot of experience, I'm sure you've had those cases where something maybe went a little bit unexpected. You had a lot of money invested in the case, and perhaps the settlement that you were provided was enough that your client can take it. You can make yourself whole on the expenses, and that could be the end of it. But of course, your goal is always to get the very best result for your client. So this kind of removes that. I don't want to say it's a conflict, but it removes any question as to whether you're going to go out and get the very best result for your client because you're removing that risk.
Yeah, it's difficult to reach into your pocket and put money into a case when you know that there's a good chance, I mean, a very good chance that you could walk away losing that money. And, this sort of takes that burden away and you can do what's necessary on the case without feeling conflicted. And, there have been many instances where I've gotten into a case and regretted it because either a fact came out that I didn't expect or the defense was more vigorous than I expected. The insurance really allows you to be aggressive, on your cases.
Well, David, I want to tell you, I thank you very much for being a Level Insurance customer. It's always great to talk with folks who've had the ability to use this and use it effectively. And we hope that you continue to use the product and get great results for your client. Thank you so much for taking time to talk with us today.
Thanks, Justin. Nice talking to you.